Hello, this is Mrs. Petty. Today we're going to talk about Supreme Court procedures. Let's get started. The Supreme Court sits for 2 consecutive weeks each month, and during that time, they hear cases that are brought before them. They hear lawyers argue different sides of the case, and they also hear the facts of the cases. They recess after 2 weeks. Now, when we say they recess, that doesn't mean that they go outside and play on the Supreme Court playground. This means that after 2 weeks, they no longer sit as one body. They retire to work on paperwork, they write opinions, and do other individual work related to the Supreme Court. Cases can reach the Supreme Court in a few different ways. They can reach the Supreme Court through original jurisdiction. And if you can think back to the last video, we talked about how or when the Supreme Court has original jurisdiction. They can also reach the Supreme Court by appellate jurisdiction through cases that are heard on appeal. Like if you have a case heard at a lower federal court and you don't like your decision, you can have that case appealed to the Supreme Court. Cases also reach the Supreme Court by something called certiorari. So let's say that I have a case and it is heard at the district court level. And I don't think that the court had all of the right information. I don't think they've made the right decision. So I decide to petition for a writ of certiorari. So I'm basically asking the Supreme Court to hear my case, but to get information from the lower court before they hear my case. And that's how you would obtain certiorari. A lot of the times the Supreme Court does not honor petitions for certiorari, so this is it's pretty rare. And also, like I said, the Supreme Court can choose what cases they want to hear and what cases they don't want to hear. Moving on, the Solicitor General is an interesting position in the federal government. The Solicitor General is not technically, he's not part of the president's cabinet, but he is a person appointed by the president, approved by the Senate, and this person is responsible for representing the federal government before the Supreme Court. Now you ask, well, what about the Attorney General? What does he do? Well, the Attorney General, I want you to think of as like a law enforcement officer, someone who's going to make sure that help the president make sure that the laws of Congress are enforced. And I want you to think of the Solicitor General as kind of like the lawyer for the executive branch. So anytime the federal government is involved in a lawsuit, the Solicitor General is the lawyer for the federal government. Now, that's not to say that the Attorney General can't represent the federal government in some instances. So the Solicitor General, he provides this unique link between the executive and judicial branches. He also can help determine what cases the government should appeal, what cases they should just let the decision stand. And we already talked about the Attorney General and the Justice Department. Moving on then to how the Supreme Court selects cases. The big issue with the Supreme Court whenever they're determining whether or not to hear a case is they're trying to figure out whether or not a case is worthy of being heard by the Supreme Court. So does the case in question involve a substantial constitutional issue? Is someone's right to freedom of speech being infringed upon? Is someone not being given due process? That kind of stuff is what the Supreme Court looks for. And I don't want you to think of the Supreme Court as deciding someone's guilt or innocence. Okay, most of the time whenever we think of whenever we think of a court, we think of them determining whether or not someone did something wrong. So think of the Supreme Court as determining whether or not someone's rights have been violated. So cases go on the discuss list. This discuss list is reviewed by the Chief Justice of the Supreme Court. And the Chief Justice, just in case you don't have this in your notes, is John Roberts. You need to know that. The rule of 4 is basically what allows a case to be heard at the Supreme Court level. If at least 4 of the justices decide that hearing a case is a good idea, then they're going to most likely hear the case. And like I said earlier, there are a few petitions for certiorari heard by the Supreme Court. So steps in deciding a major case. The first thing is you submit a brief, and a brief is just information about the case in small form. So you just basically are given the information that you need to know. Who's involved, what happened, and who feels that their rights are being violated. Sometimes we have these briefs called Amicus Curiae briefs. And basically, Amicus Curiae is Latin and it means like friend of the court. So if you are a party that has nothing to do with this specific case, but maybe you have information that might help, you could submit an Amicus Curiae brief, and that could be heard by the Supreme Court. Oral arguments, most of the time Monday, Tuesday, sometimes Wednesday. Supreme Court justices sit and they hear oral arguments from lawyers from both sides of the case. The lawyers only get 30 minutes per side, and they're basically standing behind a podium, and there's this red flashing light that will tell them, basically kind of clue them into when you need to wrap up your speech. The justices often interrupt members or the lawyers as they're delivering these arguments, so this would be a very stressful situation. The conference, this is most of the time on Wednesdays and Fridays, sometimes Thursday, Friday. And this includes only the 9 justices of the Supreme Court. They do not keep minutes, which means no one is taking notes on what's being talked about. So think about some of the positives that could come from not having minutes kept. The justices discuss and then they vote. And in order to overturn a lower court's decision, they have to have a majority of the justices. So at least 5 out of the 9 justices have to agree to overturn a lower court's decision. And then writing the opinion. This is the very important part of the Supreme Court's decision-making process. The opinion is what basically sets precedents for future cases that deal with that same issue. So first of all, they write the opinion. The stuff that goes into the opinion, basically you've got the facts of the case, you've got the court's ruling, and then you have why the court ruled that certain way, okay? So, like I said, the opinions are what precedents are based upon, and we have different types of opinions that are delivered by the court. We have a unanimous opinion, which means that all the justices feel the same way about the issue. We have a majority opinion, which is written by a justice who's in the majority. We have a dissenting opinion. So if you are a justice that disagrees with what the majority of the court says, then you could deliver a dissenting opinion. And then you also have a concurring opinion, which means that you would agree with the majority decision, but maybe you agree for a different reason. And we are going to stop there. And if you have any questions, let me know.